Yeah, and I think, usually we kick the show off with an email question. I do believe we have an email question from Natalie, if you want to go ahead and put that up. Okay, it says, my husband fractured his thumb and didn't say anything about it because he didn't want to lose his job. Now, 2 months later, his boss terminated my husband's job. He has pain at times because of the injury. Can he still file a claim on this? And that's from Natalie. So Natalie, that's a great question. It's very unfortunate about your husband. But really, anytime there's an injury that occurs on the job, people have workers' compensation insurance. I mean, there's some exceptions. There's some exceptions, but most workers are entitled, if they're injured on the job, to have their medical treatment paid for, and they get a percentage of their wages paid as well if they suffer an injury on the job. And that's regardless of how the injury occurred, whether it was the employee's fault, whether it was somebody else's fault. But there is a notice requirement. And under the statute, the workers' comp statutes are governed by Section 440 of Florida statutes. And I believe with very limited circumstances, you have to let your employer know about the injury within 30 days.
And you have to, when it happens on the job, it's so they know it actually occurred on the job.
Right. Yeah, so by statute, you're supposed to let them know within 30 days. Now, there are some very limited exceptions to that. I think one of them is if the employer was there to witness it. I think that's an exception, so they're on notice. There may be another exception, I believe, if you have some sort of an injury that you're not really sure what the cause of it was. It could have been something. These are more your exposure type cases where you develop a condition. I can think of people that might work, in construction industries. Maybe they get an injury or an illness due to some sort of an exposure. It's not readily available, but it is later then diagnosed by a doctor. Even at that point, once it's diagnosed as being something that might be work-related, you still have 30 days from that day. So with very limited exception, you have to let your employer know within 30 days of the injury. And I would encourage you to talk with a workers' comp lawyer to find out if one of those exceptions applies in your husband's case, because you mentioned it's been 2 months and he didn't report it. And look, for people out there that have been injured on the job, and employers out there, you can't fire somebody because they bring a workers' comp claim.
It's actually illegal to do that.
Yeah, it is. So it's unfortunate that your husband thought that, well, if I report this claim, I'm going to get fired. Because in the state of Florida, if you have an injury on the job and you file a workers' compensation claim and then you're terminated for that,
that's another claim.
That is an actionable claim that you can have against your employer for wrongful termination. So best bet is if you do have an injury on the job, report it immediately or as soon as you can. The employer then has a responsibility to notify their carrier. I think it's within a week, if I'm not mistaken. And then medical benefits are covered. Wages are covered. I believe it's 60% of wages are covered. And then, hopefully the person heals and gets back to work.
Yeah, and the only other thing I'll throw in, and for workers' comp claims, you do not get money for pain and suffering. It is just what we call economic damages. It's lost income, it's medical bills and things like that. But depending on how it happened, if he's on the job and another party hurts him, like we have people driving who are involved in car wrecks, and they have a workers' comp claim, but they also have a personal injury claim. So there's all sorts of things that you can look into when someone's injured on the job. But with a fractured thumb, sometimes there's medical treatment, sometimes there's a splint, sometimes there's nothing really you can do. It just kind of depends on the severity of the injury. But contacting an attorney whenever a legal issue pops up is the best advice that I'll give anybody. They can kind of point you in the right direction, or they can actually help you out.
Right. And Brian, you brought up a great point. I was going to bring that up, but you read my mind, I believe. We have cases all the time where people are injured on the job and they are covered by workers' compensation, but their injury was due to the negligence of somebody other than their employer or another employee.
Yeah.
Now, workers' compensation, the way the scheme is set up in Florida is it's considered no-fault insurance, basically.
Correct.
It doesn't matter, how the injury occurred. It's just if the injury occurred on the job, then the employer is responsible for providing coverage that will cover your medical expenses and your lost wages. The trade-off is that you don't get to sue your employer. Now, what if the employer acts with malicious intent and intentionally hurts you? That's different. They don't get workers' compensation immunity in those intentional acts. If you're injured by a coworker, like another person on the job, or maybe you're a construction worker and you're on a job and there's other subcontractors out there that don't work with you, but they're considered under the general umbrella or the general contractor's umbrella, you can maintain a claim against a coworker or another subcontractor, but you've got to prove that they acted with gross negligence, which is a higher standard than just simple negligence.
No, and that's why you need to contact an attorney.
Right.
There's exceptions where we can pursue claims, but most of the time, when you are injured on the job, your remedy is
Right.
workers' comp is to make sure you get medical treatment, you're getting paid for your lost income, and you're not falling behind because you're injured on the job,
Right.
regardless of whose fault it
Right.
is.
And then, of course, the third exception, or not really exception, the third situation is when you're injured by a third party, somebody that you don't work with, it's not your employer. Think of a company driver. You're driving a vehicle and you get in a car wreck. You could be covered by workers' compensation because you're on the job, but you could also have a claim against the person that caused the wreck in negligence, and we handle those claims all the time.
We handle those all the time,
Right.
and there's all sorts of weird things that happen with workers' comp and car wrecks. So if that ever happens to you guys, highly recommend
Yes,
contacting
at
an
the end of
attorney.
the day, I mean, these are very nuanced, and there's a lot of loopholes that you have to jump through, and that's what we do. That's what we're trained to do, is to deal with these types of claims. So, great question, Natalie. I wish your husband all the best in his recovery, and hopefully finding another position where he's able to get back to work.